Next matter is number 7, Landberg versus the City of New York.
Morning, Your Honors. May it please the Court. Michael Sanders for Plaintiff Appellate, Judith Landberg. We're here today to appeal the lower court's decision on liability for the defendants Whitman and defendant City of New York. Regarding defendants Whitman, who were the landlord, the heart of the appeal is how a sidewalk is defined under 7210.
Well, counsel, let's talk initially about the area where plaintiff's trip occurred. In this case, it seems that plaintiff or the trip occurred on a stone or brick that was part of a tree well. And under well-established case law, it has been determined that under these types of circumstances, the owner of the abutting property is not responsible for any injuries that occur when the accident occurs in a tree well.
So what a plaintiff is resisting is the classification of those bricks as the tree well. The lower court determined it's part of the tree well.
We have photographs that would seem to clearly depict a tree well.
But under what definition is it a tree well? Under the Vucevic court that gave the exception under 7210 for tree wells didn't actually go into what the definition of a tree well is. And 7210 describes, puts the onus on the landlord to repair, keep safe the sidewalk, and the sidewalk has been defined in other cases.
Well, which case are you referring to?
And what other cases has it been defined as? Just as examples from this
case. Which case are you referring to, or cases?
In this court has ruled on a case called Kaimatov that brick pavers are considered part of a sidewalk. Now that wasn't a tree well case. Kaimatov, Khaimatov.
Go ahead.
So, plaintiff's position is that
because in your brief you referred to one of the cases, Victic, the Epsom Downs,
sure,
and City of New York, Ivory against City of New York, but those cases seem distinguishable.
So right, so Vucevic, it stated that.
Well, you have photos in this case that reflect that the area that has been referenced as a tree well, it's an area that's not fully paved, and it's also not fully flushed with the sidewalk. So it would seem distinguishable from the cases that you rely on.
Well, so I mean, again, it was paved, as in with bricks, okay, and this court has already determined that bricks can be considered part of the sidewalk under 7210. They were no longer flush with the sidewalk, but that's the defect that we're here to. That's the defect that we're here to argue today. If it was flush with the sidewalk, there wouldn't have been an issue.
Anything further on that issue?
Yeah, I mean, just in terms of defining what should constitute the sidewalk, I think the pictures show that you could not have entered vehicles that would park there without traversing those bricks. So, I mean, those bricks were clearly intended for pedestrians to pass through. And just, I mean, they're just the practical consequence of Respondent's position. The defendant acknowledged seeing a notice of the defective condition. Year after year, it getting worse, and they did nothing about it.
So you're moving on to the issue of prior notice?
I don't think notice is at issue here.
Okay.
I'm just speaking of the practical issue of what, if 7210 was enacted because the landlords are in the best position to take care of the roadway in front of their building. And I mean, I think this clearly establishes that they were on notice of it, they were aware of it, but because they themselves determined it was a tree well, they did nothing about it.
Well, as you indicate, prior written notice, you don't view that as being an issue here. But there is another issue that I would like to move on to, and I'm going to ask you to address it. And that is, in preparing for this oral argument and reviewing the brief of appellant, it came to the attention of the court that the brief submitted by plaintiff cites to at least 3 cases that appear to be fictitious. Haza versus Quinta, Lack v. Lack, and Zhang Fuji versus City of New York. None of these cases, nor the quoted language, appears to exist. And with respect to the last case I mentioned, the last purported case I mentioned, the Zhang case, the plaintiff's brief purports to quote from a case and incorrectly attribute certain language to the Court of Appeals.
For which case?
The XIANG. And also, and I just want to tell you about some of my other concerns, and then I'm going to ask you to respond.
Sure.
There are 10 other cases cited in plaintiff's brief, some of which appear to misrepresent the law to some extent. So these are concerns that I have as a member of this court, and I'd like you to address this issue.
So
how do you respond?
Plaintiffs cited a plethora of cases. Those specific sites that Your Honor is referring to wasn't brought up in opposition, so I wasn't specifically prepared to speak to them. I'm not sure what the...
Well, counsel, before you go any further, let me point out to you that Rule 3.3a of the Rules of Professional Conduct indicates that a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. It doesn't depend on whether your adversary points out to you a possible fictitious case.
Sure.
It is the responsibility of the attorney submitting the brief to the court. Now, I've just advised you that at least 3 cases are apparently totally fictitious. They don't exist. The purported citations don't exist for these cases.
I was only pointing out that the opposition...
So how do you respond? You have submitted this to the court.
If there's any citations that are incorrect, my deepest apologies.
Where did you get them from?
I don't know what these cases were specifically...
Do you want to take 10 minutes and go look them up? We give you 15 minutes to go and you can find them? I mean, you wrote this, right?
Yeah, I wrote this, yes.
You wrote this?
Yes, so if...
You wrote this?
I wrote this.
You're responsible for it?
I'm responsible for this and the reply.
Okay. And every case you used, you found in a book, Westlaw, or Lexis. Is that correct?
Or cited from a previous case, yes.
Okay. Do you want us to give you 15 minutes so you can tell us where you got these? Because I don't counsel. I hope you're an officer of the court.
Sure.
Okay?
Sure.
You tell me you found these in a book.
Or
you found these in Lexis, Westlaw, or some other, or in a physical book. Is that where you're saying you got these cases?
Or in Westlaw, or in a previous, I may have used...
Just so you know, because I don't want you to dig a bigger hole here.
Sure. Sure.
You're citing principles that don't exist.
So, I'm resisting...
Let me tell you something.
Sure.
Okay? We saw this last week. I was hopeful that in preparation for today, that you were going to read this and say, oops, we made a mistake, Judge. Happens sometimes, right? People put a cite into incorrect, Scribner errors, etc. That's what I was hoping for.
Sure.
Didn't get that. Should we give you some time right now to go look these cases up?
I think it's going to take me more than 15 minutes. I just want to explain, I was very focused on the case law that I really thought was most relevant towards the heart of the issue.
I understand. You understand what's our concern?
That there's cites in the case that don't exist, cites in my brief that don't exist.
Would you agree it's a legitimate concern?
That's absolutely a legitimate concern.
You know, in my professional career, I've seen a lot of things, okay? We all have. I don't want to speak for my colleagues, but I'm confident they all have. And I'm sure you have too. I think every lawyer here has seen it. Times when you put a case into Lexis or Westlaw, or in the old days when we had to open up the book, and there's a Scribner's error, right? And you're like, okay, it wasn't page 344, it was page, 644.
Sure.
Okay? But we can find the case because you can see where the error was made, because you know the case exists. You're able to find it. It's a pain in the neck.
Sure.
But it happens. And we've all been there. I'm sure you've been on the other side of that where a lawyer's done that to you, put it in a brief or in a motion papers. It's not a big deal. It's annoying, but we get past it. This is something different. This is a wholesale creation of cases. And I'm concerned that you're citing cases that don't exist. That's a big concern. This is not me pulling one case out of a string cite.
Right.
Okay? I understand you might not, you should be, you might not have read every single case in a string cite. These are, you're suggesting the Court of Appeals said things they didn't say.
Okay, if I again, I mean, I would have to review my papers. I think with Zhu, I think that was an appellate decision that actually wasn't a Court of Appeals decision that I was mistaken about. Again, like I said, I was really focused on the cases. The reason why I don't know every single case is I was really focused on the cases that most of my brief was relying on, which was...
But counsel, some of the fabricated quotations used to support your primary argument are contrary to actual law. Actually contrary to what the law states on your primary arguments. These are not minor side issues. These are issues that you offer, that you put before this court to support your primary arguments. It is concerning, and we're bringing this to your attention so that you may explain, if possible, how this occurred.
I mean, the only thing I could think of is just me over-relying on other briefs and maybe string cites for general case law. But in terms of specifically about the issue of bricks...
Let me interrupt you. You wrote this, right?
I wrote this.
You're responsible for this.
I'm responsible for it, yes, Your Honor.
You're responsible. You're not gonna tell me some associate at the firm stuck something in there that you didn't see.
No.
You wrote this.
Yes.
Anything else you want to add? Anything else? You have anything? You have anything? Anything else you want to add?
I guess no, nothing further. Thank you, Your Honors.
Thank you.
Good morning, Your Honors, and may it please the Court. Ross Frischer for the owner respondent. Here, the motion court correctly awarded summary
I
judgment.
got to ask you a question
Sure.
before we get to anything else.
Yes.
You saw that these cases were, when you read your adversary's brief, do you actually check the cases?
Yes, Your Honor.
How come you didn't bring it to our attention?
So with this particular scenario, I was more focused on the specifics concerning...
He was raising, he referenced Court of Appeals standard that doesn't exist. He was using it as a component of his argument, and you didn't think you should bring it to our attention?
So, Your Honor, I didn't notice in particular that the principle of law that he was citing was incorrect. Over here, it says in one of the cases that Your Honor mentioned that 7210 should be construed liberally to effectuate its remedial purpose. That's correct. Is there another case that I should address? Because with that principle of law, that's...
Counsel, I'm going to give you a chance to make your argument.
I'm sorry?
I'm going to give you every opportunity to make your argument. But I'm befuddled. I honestly am. I'm absolutely, and I'm not here to... Lawyers make mistakes. It's not an easy profession. I don't want to sit here beating up on lawyers, but we rely on the bar so much in what we do. So the first thing that I did, I don't want to speak for my colleagues, but after seeing what he wrote, when I went to your papers, I expected to see something referencing, not just, it wasn't one case, counsel, it was several cases. And you didn't see fit to bring it to our attention either. It's just striking to me. I'll let you make your argument.
Yeah, so Your Honor, I apologize to the court. I will do further due diligence going forward from this point on.
I hope so. You should apologize to your client, not to me.
Yes, I apologize for that, and I will, going forward, check every single case, even if it stands for, general principles of law, like the construed liberally to effectuate a remedial purpose and things like that. I will bring them to the court's attention.
Counsel, the misrepresentations here are of such a degree that they could not merely reflect a difference of opinion. As an appellate court attorney, you would have to, if you were doing the work and reading the briefs and responding to the briefs, you would have to notice that something in the wording of the main brief for the appellant was wrong, if not many things being wrong. It's concerning because we are all officers of the court, and there is a responsibility that you also have to notify the court, to do the work, notify the court when these types of misrepresentations and fictitious cases and fictitious citations and misrepresenting the holding of a Court of Appeals case. And I could go on and on. But if you read the brief and looked at the cases, you would have realized it was your responsibility also to alert the court. How do you respond?
So, Your Honor, what I can say is we write these briefs normally to be very, very focused on the issues here, and that is a big issue, and going forward, I will, make sure to check every single case that is cited, even Court of Appeals cases. But when I write the reply brief, I usually tailor it to be very specific to the dispositive issue here. The propositions that were cited or misattributed to certain Court of Appeals cases did not immediately raise a red flag as I was writing my brief. What raised red flags was the application of the law as it applied to appellate precedent in this department, which concerns what a tree well is. And, in that search, I relied on one case, Ivry v. City of New York, that is, I think, dispositive here, that, shows a picture of a brick that is nearly identical to the brick at issue in this case. And that's really the dispositive issue. As far as I see here, the Court of Appeals on page 14 of the appellant's brief, 7210 should be construed liberally to effectuate its remedial purpose. I think that's a generally accepted principle of law, and quite frankly, that's why I missed it. So, again, my apologies to Your Honors. I will be more diligent in the future. And if there's anything else on that point that I can answer, I'd be happy to. But again, I will be more diligent going forward. I hope Your Honors can accept that from me. But in terms of the actual dispositive issue here, which is, again, the cobblestones that are surrounding the tree well. Again, page 78 of the record shows a picture of where the plaintiff identified at her deposition exactly where she fell. And she circled the brick closest to the tree, clearly within a flag of sidewalk that was taken out. And there's dirt and there's cobblestones. And here the city admitted to installing that. On those 2 points alone, I believe that that's enough to affirm the lower court's decision. And unless there are any further questions from the court, I'll rely on my brief.
Thank you for your time.
Thank you.
Good morning, Your Honors. May it please the Court, Elizabeth Friedman. I'm appearing for Respondent, City of New York. Your Honor, in the appellant's brief, point three addresses the issue of the prior written notice, and that was the point of the brief that we in my office and I focused on.
But of course, you read the entire brief of the appellant, is that correct?
Yes, Your Honor.
So how do you explain your failure to bring to the attention of this court that a brief was filed with this court by appellant's counsel with apparent fabrications and misrepresentation?
Your Honor, the point of the brief dealing with the owner's liability, we didn't take a position on the owner's liability. We didn't, and I certainly read the briefs. I certainly read all of the briefs here, but I certainly didn't focus on it because it was not our issue. And I do apologize to the court for not catching that, but I tended to focus more on the issue of prior written notice. In that point of the brief, the plaintiff cited two cases. Neither one of them raised red flags. Those two cases are Porosnik, where it says that an exception exists for the municipality affirmatively created the defective condition. That seemed to be accurate. That didn't raise any red flags. And the only other case they cited in that point is Rogers versus City of New York, stating that a 2-year search is sufficient and can be sufficient. In our brief, I tried to state the law correctly.
Counsel, I suggest that at some point in the very near future, you return to your review of Rogers v. City of New York, because I have some concerns that is a case that appears, as it appears in the appellant's brief, it appears to misrepresent the law to some extent.
Your Honor, so in that case,
So I would
Yes.
I would tread very lightly in discussing with this court that you feel that the reference in appellant's brief to Rogers v. City of New York was appropriate.
well,
I don't agree with that.
okay. I apologize, Your Honor. It seemed the part I was reading, it held that a 2-year search can be sufficient. And I basically cited many cases in our brief that basically stated that a 2-year search is sufficient. So I tried to state the principle of law here accurately, and I basically felt that it was just simply a statement of the law about a 2-year search. And I did not delve into that particular case to see what the holding was, since it didn't seem that was that the plaintiff was relying on that, other than to state that a 2-year search can be adequate, but that they're basically stating that held that a 2-year search can be sufficient, then goes on to say that holding is not a blanket rule applicable in all circumstances. So I felt that was the opinion of counsel and not the holding of the court in that case. But in our brief, we did cite cases that do unequivocally, from this court, unequivocally state that a 2-year search for records is sufficient, and that here the city demonstrated the lack of prior written notice, and that the plaintiff in opposition did not create an issue of fact as to whether or not the city affirmatively created the condition through an affirmative act of negligence. The undisputed evidence from the building superintendent was that the bricks were even when they were installed, and that they became uneven over time. That is certainly not affirmative negligence here. And again, Your Honor, I apologize. I tried to state the law accurately in our brief, and I apologize for not looking at the entire panoply of cases cited in the brief, since that was not the focus of our particular issue in this case. And we do feel that summary judgment was correctly granted as and dismissing the case as against the complaint as against the City of New York for the reasons that the Supreme Court stated in its decision. And unless the court has any further questions, we rest on our brief. Thank you, Your Honor.
Thank you. Well, don't go anywhere yet. Don't go anywhere yet. Have a seat. Everybody have a seat. I just want to say this to you all again. This is a very distressing situation for the court. I know this is an outlier. We're very fortunate, my colleagues and I. We have the privilege of working with what I think is one of the best benches in the state. bars in the state, pardon me, the Appellate bar here in the city of New York and its surrounding suburbs. We see excellent work. For me, personally, it's been the highlight of my career to have the opportunity to work with such outstanding judges and to have the opportunity to work with such outstanding lawyers. But part of this profession, a big component of it, is that there's a element of trust. And mistakes are made. We make mistakes as judges. We've made mistakes. I don't want to speak for my colleagues, but I dare say that we've all made mistakes as practitioners. And we work very hard when there are mistakes to try to give the benefit of the doubt to those lawyers who practice before us. We know how difficult your respective jobs are. And in reviewing this, I know my colleagues and I have tried to give every benefit of the doubt to the lawyers before us. But the lawyering that was done here, at least as far as the briefs and specifically the promulgating of false cases that don't exist, quoting quotes that have no support in the law and purport to quote cases that don't exist, is well below the standard we expect from the bar. I can just tell you, unless, again, maybe there's an explanation and maybe you'll have one for us and at some point, and I hope that there is one. I really do, because it is striking and concerning, disappointing, and saddening to think that members of the bar would forward cases to a court that don't exist. And to think that the lawyers on the other side of that didn't read it for whatever reason, didn't check it. It just seems to fall well below the standard that we've all become accustomed to from members of the bar in the Second Department. Have a nice day, everybody.
Again, I just want to apologize to the court and just...
You'll have an opportunity to apologize in a different way. Why don't you do your research and find out how that happened, though, okay? We are going to consider, just so you know, we're going to consider whether or not an order to show cause for sanctions should be handled. You'll have and if we do decide to have one, if we decide to issue one, you'll have an opportunity to explain why we shouldn't do that, okay? Have a nice day.